Hi everyone, you're welcome to our week 3 and week 4 lectures regarding the legal and ethical issues in counseling. By the end of this lecture, we shall appreciate how to deal with an adolescent and how to deal with where the adolescent and the child is coming from in terms of the family. And I implore each and every learner to take this particular course very serious in the sense that you are going to deal with diverse individuals and you must know the pros and cons that underpin how you go about most of your ethical dilemmas that you may encounter. In fact, there are several unique legal concerns of which therapists need to consider in as much as children, adolescents, and their families are concerned. However, most of these ethical concerns are not generally emphasized in our training. But you people are so good that we have had encounters, and that has led us to propose a course of this sort for you to learn and be guided by its core tenets. These ethical codes vary among different organizations, especially those who are dealing with marriage and family therapy, those who are dealing with general counseling, some people psychology, others social work in general. So we are going to address issues of informed consent when it comes to dealing with children, confidentiality, exceptions and how to report cases, sharing information, and again, subpoena when you are being charged by a court to appear before it and give information about your client. That's what we call subpoena. I don't say subpoena, I don't say subpoena. It all depends on where you attended your judges. But in the legal pronunciation, we say subpoena. You have been subpoenaed to bring on board or to reveal information of your client. Important topics are the importance of counselor competencies, multicultural considerations, special topics including the use of touch and role of professional in diverse situations. There are many instances for someone to become sweet or to go in line with the therapy, you need to hold the person, that is touch. But sometimes some of the touches become so erroneous and erotic in nature. So we think about it. The role of computing, how to use computer and social media in enhancing the relationship for children or the sources of stress or trauma to them as well. We are also going to talk about the laws that go beyond ethics, which vary according to country, state and state, region and region, municipality and municipality. However, there have been little guidance in mental health literature about these ethical issues that may come up when we are counseling or dealing with minors in the school setting or outside the school setting. Even popular textbooks that we know that convey information about how to deal with the individuals are not making it clear to us as to what to do, what not to do when it comes to dealing with minors. The potential and legal ethical when treating children or young ones are numerous, as I've indicated earlier. So child rights confidentiality, informed consent, child and divorce, the use of touch, counselor competency, and the multicultural issues are going to be discussed. First one is privacy. Privacy. Every counselee or client has the right to choose who has access to my information or not. So parents are those who are having the mandate to own the information of their alleged adult children or those that they take care of directly. and the parents make decisions for these children. So whatever the parent is going to do or the child is going to face, in as much as counseling is concerned, is the parent that will decide whether we do or not. So decision about protecting the children's privacy, confidentiality in dealing with them is examined from both the legal and ethical lenses or perspectives. There are also limitations. Sometimes, not everything of the child is said. We conceal some of them. We have confidentiality. This angle is about how secret we become with information that is given to us by our clients who are children, adolescents, or their family. So we keep the information private to the extent that no other person gets access to that until those who are responsible for the situation. So all codes of ethics in the mental profession address confidentiality, and any information that is given to you as a counselor should not be shared with others without the authorization of the one that you took the information from. And such authorization should be done through writing. So what we include in the releases is typically dictated by the mental health authority or the organization that give you a license to operate. We have privilege. It is a right owned by the client, and it protects the client from any harm or any situation, and it makes the client very private in terms of the information. And when it comes to legal situations, because of the privilege, the client can choose to talk, can choose not to talk, and they cannot be compelled to talk. So these privileges are established by state statutes or state institutions. And not all clients hold privilege. Sometimes it depends upon the type of counselee relationship, that is therapeutic discipline, that is covered in the law. So some states allow privilege to adolescents at the age of 16 for specific issues, others to 18 in the sense of Ghana. So the legal right to privilege communication can only be waived by the client, although in the process of a legal discovery, attorneys or lawyers often subpoena counselors or their records. Unless a client has veiled or given the chance for you to know much about them, that is waiving the privilege, the counselor is obligated to appeal the court to uphold state statute and keep the counseling information confidential. So when the client has not given you the red line or the green line to go in for their information in terms of privilege, you, the one who is dealing with the client, can write to the legal authority, exempting yourself from that so that you don't divulge the information of the client to anyone. But there are legal prescribed conditions for which the counselor is not subject to prosecution for withholding information needed by the court in litigation. Sometimes if the client's practitioner or when the counselor refuses to go by the order of the law, there are specific laws that they use as basis, of which that particular counselor may not be held for any refusal to do this or that, because they have that right in legal terms. We have harm to self. Any client that is less adult, of which we have control over, may be at risk for depression should we divert their information to another person. So we need to always make sure such an individual is being protected in that he's not hurt as to whatever situation he or she goes through with you. Sometimes the harm comes into many forms. You need to suspect if there's a likelihood of harm or there's a special relationship that exists. So the duty to warn occurs when the following three conditions are met. When the person wants to harm another person or harm another person, harm himself, a family member, and so on and so forth. So when you suspect there's a likelihood of harm, you need to warn. When you think that the person has been consistent in that, you need to warn. And when you see that this person is the one that is likely to be affected, you need to warn. That is, there's a feasible victim. Abuse. Abuse is when you are being neglected, when you are being subjected to maltreatment. And abuse comes in several forms: physical abuse, emotional abuse, social abuse, and so on and so forth. Usually, the emotional abuse is most common. The physical abuse sometimes is common, but specific to situations and cultures that we find ourselves. So state law requires professionals to report any child abuse or neglect. And in most instances, we fail to do so because we think we live in a society, even a parent may be abusing the child. But because that's the son or the daughter, you think it is right and you allow. Let's be careful. Abuse is abuse, and abuse should be reported according to the law for the right to be done to protect the child, adolescent, or their family from subsequent harms. Subpoena as a threat to confidentiality. When a counselor receives a subpoena, no confidential information should be released to any attorney just for the asking. No. When you are being subpoenaed by the court, don't release the information. Why? And here are the steps. Read the subpoena very carefully and get to know what it contains. And ask, is the attorney law asking for specific information for the case file, for a testimony via court or deposition? Is it all the information that they need or specific ones? You need to know this. Second, talk with the client. Engage those that they need their information, regards to how they want the information to be handled in terms of the subpoena. If they give you the right way, you follow. If they don't, you withhold. You can be surcharged. Third one, talk to both the parents of the child who has been subpoenaed and the child regarding the dispensation of the information. Sometimes some laws supersede others. So you may think that you want to withdraw or you want to ignore the subpoena, but there's another law that is used as a caveat that can be used against you. So you discuss all these things to understand and appreciate before a decision is made regarding whether to accept or not to accept. For the fourth one, a judge may order information to be revealed in spite of the therapist's stated rationale for why the information should be kept. Sometimes the force will lie on you, the therapist, to release it regardless of whatever justification that you offer. In this sense, you need to operate in a way that harm is not caused to the client and you, the professional counselor. Finally, do not take the case records to the court unless they are specifically requested in the subpoena. Remember, you have a case record. Just go there. Don't carry every record along with you. When they request for them by writing, specifically stating what they want, then you carry it along. Don't take them there. It's not their document. It's for you and your client. How do we share information with parents? Even the client that we are dealing with, their parents is their parent, but not every information needs to be known by the parent. Let's say a school case, the child is a lesbian, the child is a gay. The child may not want the parents to know it. When they tell you, I've sent you to be in a counseling therapy, but don't let my parent know. Yes, you should not let the parent know. You must go professional with the child and change the child from the situation. So the parent will not know that the child is a lesbian or that. There are several types of confidentiality. and how to manage it. And Hendricks gave us 4. Complete confidentiality. Complete confidentiality, 1. Second one is the limited confidentiality. The third one is the informed forced. And the fourth one is no guarantee of confidentiality. So the complete confidentiality means you hold a lot of information and you are being what? Mandated by law not to. Second one, limited. In some situations you agree, in some situations you are not. That is a limited. The third one, informed forced. Here, the child has no voice in what is disclosed, but is informed before the disclosure is made. So sometimes it could be so peculiar that no matter what or how secret the situation is, the parents of the child need to know. So we do inform forced confidentiality. And the fourth one, no guarantee. So this one is made to a child. Secrets that are held by a counselor can impede individual and family work. So in using this approach, it is very important that children and their parents are told at the start of the therapy for them to understand, either through verbal or through writing. We have the mutual agreement. The mutual, that is a mutual, that is a mutual. It all depends on where you attended your JHS as to what will be disclosed to the parent and what will not. For example, some parents will want to know about an adolescent sexual activity. Others will not, because they cannot contain the situation. So they wouldn't even need to hear it. The use of alcohol may not be need to be disclosed. But what if the counselor learns that the client is drinking and driving? That one they need to tell. And finally, best interest. You think about what interest it will serve. If you disclose, does it have any repercussion on the client? If yes, don't disclose. If no, you can disclose. That is best decision. So some counselors will set up a best interest agreement with the child and their parents before disclosing. We have group confidentiality, which comes as a result of what group counseling. What is the role of a counselor in treating minors? The treating counselor for the child parents. So you, the counselor, your role in the manual is that you treat them. You are their evaluator. You are their guide and lead. You are their mediator. And you are their expert critique. So you treat, you evaluate, you guide, you mediate, and you expert in whatever that you do or you say, or whatever information that you offer to some people who may want to have a discussion regarding that particular individual. So first, it is vital to clarify your role with the client, being the child and their parents. Secondly, you need to emphasize to parents the importance of focusing on the child's welfare. Third, you need to establish the rules. If doing an evaluation, discuss with whom it will be sent. So if these things are done, it will guide your process of therapy. The role of counselor in working with the children of divorce is also being given. So how do we use touch? You ask yourself, what are the possible benefits? What considerations are related to the counselor? What safety issues are related to the child? These are rhetorical questions that you ask yourself. What in this child's family background might be an issue? And what are some practical considerations? So when you have these questions in mind, you are able to work with the child by touching. So let's go individually. What are the possible benefits of the touch? Touch can be reinforcing and calming. How might this child perceive the touch? It could enhance self-esteem or make the child feel powerless to comment on it. In 2019, a student of mine, late adolescent, now in UK doing a PhD, was being neglected by the partner. And she was feeling restless and wanted to even stop schooling. So I rented a hotel for her. I said, weep. If the broken heart will let you die, cry the whole night. She wept and continued and later stopped. But as I was consoling her, I was touching to let her have a calming feeling. And eventually, she forgot about the guy and now outside the country. So touch has significance. What considerations are related to the counselor? Who needs are being met? Is the touch genuine? Some touches are meant for sexuality. So think about it. What safety issues are related to the child? Is it harmful to the child in terms of the touch? Does this child have a history of abuse? If so, touch could be alarming. Sometimes people touch and end up abusing the child by engaging them in sex and the rest. Or the touching become beatings instead of calming. What in this child family background might be an issue? You ask yourself. And what are some of the practical considerations? Culture should be considered. Some cultures will not agree to touching someone's wife, touching someone's husband as a woman. It will like you are seducing the person to sexuality and you can be taken upon. So think about that. If touch is going to be made or used at the onset of the therapy, try to discuss with the client. If they agree, you continue. If they do not attempt it. We have multicultural issues. Remember, we are not coming from the same culture. Each culture and what they tell us to do regarding how to deal with their children, their adolescents, and their family. So if you don't think about multicultural settings and where we find ourselves, you may end up doing the undone. If you do the undone, it will go against you. So the multicultural setting is very, very critical and important to us. This ends the lecture, and I would want you to listen, jot down your questions, and present them on our common platform so that I'll offer you the best response as it is needed. Have a wonderful day as we end our class.